All right, myself Kumar Saurabh, I'm present in front of you students with a passage of critical reasoning. So first of all, what we are going to do is we are going to go through the passage in brief and we'll try to understand and analyze what exactly the author is trying to say to us through this piece of writing, and then based on that we are going to solve a set of 5 questions, and we'll see how it goes. So without wasting any more time, let's get started. Let's see. The Karnataka High Court on Wednesday issued several directions to the state government to ensure proper implementation of the provisions of Prohibition of Employment as Manual Scavengers and their Rehabilitation Act 2013. सेल्फ एक्सप्लेनेटरी इन नेचर है. कर्नाटका हाई कोर्ट के बारे में बताया जा रहा है कि इन्होंने बहुत सारे डायरेक्शंस इशू किए स्टेट गवर्नमेंट को, ताकि ये जो एक्ट है, ये जो लॉ है, मैनुअल स्कैवेंजर्स एंड देयर रिहैबिलिटेशन एक्ट ऑफ 2013, इसका प्रॉपर इम्प्लीमेंटेशन हो पाए. जैसा कि आप लोग जानते हैं, मैनुअल स्कैवेंजिंग इन इंडिया इज समथिंग विच इज नॉट लीगल. अ डिवीजन बेंच, while hearing a petition filed by the All India Council of Trade Unions and High Court Legal Services Committee, observed, क्या observation था? Let's see. There can be no dispute that our constitutional philosophy does not permit any form of manual scavenging. We already know that. Right of a citizen to live with dignity is an integral part of the fundamental rights guaranteed to the citizens under Article 21 of the Constitution of India. The preamble of the Constitution shows that the Constitution seeks to protect the dignity of an individual. There can be no dispute that manual scavenging is most inhuman and it infringes dignity of an individual. The fundamental rights guaranteed again under आर्टिकल 21. तो ये जो कमिटी थी और ये जो ट्रेड यूनियन का जो मेंशन किया गया है यहाँ पे, इससे हमें ये पता चल रहा है, एक ऑब्जर्वेशन था इनका, और इस ऑब्जर्वेशन में इनका ये कहना है कि हमारे कॉन्स्टिट्यूशनल फिलॉसफी के अकॉर्डिंग देयर इज नो स्कोप दैट वी परमिट समथिंग लाइक मैनुअल स्कैवेंजिंग, बिकॉज आवर कॉन्स्टिट्यूशन इंश्योर्स दैट ऑल द सिटीजंस गेट अ क्वालिटी लाइफ एंड दे आर एबल टू लिव देयर लाइफ विथ डिग्निटी. तो ये चीज अगर मेंटेन होनी है तो मैनुअल स्कैवेंजिंग को हम लोग परमिट नहीं कर सकते. एज सिंपल एज दैट. द बेंच हेल्ड दैट इफ एनी सिटीजन इज फोर्स्ड टू डू मैनुअल स्कैवेंजिंग, इट विल बी अ ग्रोस वायलेशन ऑफ हिज फंडामेंटल राइट conferred under Article 21 of the Constitution of India. आर्टिकल 21 के बारे में मेंशन कर दिया गया. नाउ लेट्स मूव ऑन टू आर्टिकल 47. अंडर आर्टिकल 47 ऑफ द कॉन्स्टिट्यूशन ऑफ इंडिया, which is a part of directive principle of state policy, DPSP जो आप लोग कहते हो, the state is under an obligation to endeavor to improve the standard of living of its people. Okay, तो DPSP के अकॉर्डिंग स्टेट ये हमेशा एंडेवर करेगा कि वो स्टैंडर्ड ऑफ लिविंग अपने लोगों का इंप्रूव करे हमेशा. The court also highlighted the major difference between the old act. एक ओल्ड एक्ट था और एक नया एक्ट है. ओल्ड एक्ट 1993 का था और नया 2013 का है. ओल्ड एक्ट वाज नोन एज एम्प्लॉयमेंट ऑफ मैनुअल स्कैवेंजर्स एंड कंस्ट्रक्शन ऑफ ड्राई लैट्रिन्स. प्रोहिबिशन एक्ट 1993. तो इन दोनों के बीच का डिफरेंस भी हमें समझने की जरूरत है. कोर्ट ने इसको हाईलाइट किया, ये बताया जा रहा है. देन it said that the definition of manual scavenger in the Manual Scavenger Act is much wider than the definition of manual scavenger defined under the clause J of section 2 of old act. तो नए एक्ट में मैनुअल स्कैवेंजर का जो डेफिनेशन है वो काफी ज्यादा ब्रॉड है in comparison to what it was in the previous act. Then under subsection 1 of section 5 of Manual Scavengers Act, there is a complete prohibition on manual scavenging. अब complete prohibition हो चुका है. Under section 3 of the old act, the state government was required to issue a notification for prohibiting engagement or employment of any person for manual scavenging. पहले notification issue करती थी state government. The court said it added, thus under the old act the prohibition was not automatic, the provisions of the new act are more comprehensive. तो अगर आपको और कुछ याद ना रहे ना इतनी चीजें पढ़ने के बाद, तो इतना जरूर आप याद रखोगे कि as far as the differentiation between the old act and the new act is concerned, the major difference is under the new act the prohibition on manual scavenging is automatic, but it was not so in the previous act. Then let's move on. On going through past orders passed by the courts and the compliance reports filed, the bench said, we have found that there is hardly any implementation of the provisions of Manual Scavengers Act and the rules in the state of Karnataka. अब ये बात बताई जा रही है कि यार केयरफुल ऑब्जर्वेशन के बाद तो हमें ये पता चल रहा है कि इम्प्लीमेंटेशन तो एकदम ही नहीं हो रहा है, हार्डली देयर इज एनी सॉर्ट ऑफ इम्प्लीमेंटेशन देन एंड ऑफ द मैनुअल स्कैवेंजर्स एक्ट एंड एज वेल एज द रूल्स in the state of Karnataka. So we are basically talking about the state of Karnataka only. Therefore, this is a case where continuous monitoring will be necessary and the power of issuing continuing mandamus will have to be exercised. So that is it as far as this passage is concerned. Now, I hope that you guys have understood everything in the passage. There is nothing in the passage that you won't be able to understand easily. So the first question is, if true, which of the following options would weaken the author's argument? Would weaken the author's argument. The right answer here is option D, which says Article 21 being a fundamental right is enforceable by the courts and the violation of its provisions by manual scavenging can be avoided by the same procedure. तो देखो ये वीकन इसलिए कर रहा है ऑथर के आर्ग्यूमेंट को क्योंकि ऑथर ये जो एक्ट बना है मैनुअल स्कैवेंजिंग का उसके बारे में बात कर रहा है, हाउ इट इज नेसेसरी, हाउ इट इज इंपॉर्टेंट एंड हाउ इट इज बेटर देन एनी अदर एक्ट इन द प्रीवियस एरा. बट अगर ये बात सही है कि आर्टिकल 21 जो है वो एक फंडामेंटल राइट है विच इज इन्फोर्सिबल बाय द कोर्ट एंड कोई भी वायलेशन अगर आर्टिकल 21 का होता है तो वो भी सेम प्रोसीजर से अवॉइड किया जा सकता है इन द केस ऑफ मैनुअल स्कैवेंजिंग एज वेल. तो कहीं ना कहीं द रिक्वायरमेंट ऑफ अ एक्ट, अ लॉ, अ स्टैट्यूट वो यहां से खत्म हो गया अगर ये चीज सही है तो. सो दैट इज व्हाई इट इज वीकनिंग द ऑथर्स आर्ग्यूमेंट. लेट्स मूव ऑन टू द नेक्स्ट क्वेश्चन. नेक्स्ट क्वेश्चन इज, व्हाट इज द रिलेशन बिटवीन द स्टेटमेंट राइट ऑफ अ सिटीजन अंडर आर्टिकल 21 ऑफ द कॉन्स्टिट्यूशन ऑफ इंडिया. ये जो स्टेटमेंट था पैसेज में, इसका रिलेशन क्या है ऑथर के आर्ग्यूमेंट से? द राइट आंसर हियर इज गोइंग टू बी both are in support of the dignity of the people. Both are against in human practices, not so much. Either A B नहीं हो सकता, both A B भी नहीं हो सकता. So here A is the right answer. Straightforward question था ये. Let's move on to the next question. The central idea of the passage as portrayed by the author can be best explained by which of the following options? Option. Here the right answer is going to be, yes, option B. It is going to be B. The constitution and various laws under it are aimed toward protecting the rights and dignity of the citizen. यही चीज तो बात, इसी चीज पे तो लाइट थ्रो करने की कोशिश की जा रही है ना. पैसेज अगर नहीं भी समझे हो ना, अगर पैसेज एक बार पढ़ लो ना, तो ये सारे क्वेश्चन तो ऐसे चुटकी में बनेंगे. दैट इज माई गारंटी. देन लेट्स मूव ऑन टू द नेक्स्ट क्वेश्चन. An assumption for the passage above would be in line with which of the following option? Assumption क्या हो सकता है इन options में से? Basically आपको ये बताना है. Yes, the right answer here is the new act on manual scavenging came out to be against the rights of the people. Oh, can it be the right answer? We'll have to see. A. Laws on manual scavenging need attention for their better understanding and implementation. So see, A cannot be the right answer because A is explicitly mentioned in the passage, and if anything is mentioned in the passage, that cannot be your inference or your assumption. ये चीज हमेशा आप याद रखोगे. हाँ. Then B, situation of manual scavengers in Karnataka is praiseworthy. ये तो हरगिज नहीं हो सकता, because we have evidence in the passage which are talking in contrary of this option. C क्या है? The new act on manual scavenging came out to be against the rights of the people. हाँ, यही होना चाहिए, because और कुछ यहाँ पे. So basically यहाँ क्वेश्चन था, an assumption for the passage above would be in line with which of the following option. आसपास कौन है assumption के, कौन सा option? Most probably all the other options are not that strong, so we'll have to say that C is the correct one, because oh no, here D is also there, which says that none of the above. The new act on manual scavenging came out to be no, yeah, the confusion is no longer there. C is the right answer, because basically C is saying that the new act which came into existence, that came against the right of the people endowed to them, enshrined in the constitution. जो rights है उसके लिए आया है, उस वजह से आया है ये act. So that is why C is the right answer. There is no better option available in this question. So let's move on to the last question. Which of the following option did the author use as a suggestion for the problem being discussed in the passage? As a suggestion हम लोग कौन सा option choose कर सकते हैं as a suggestion? Here the right answer is, of course, constant monitoring and the use of judicial powers by the court. So you just saw how easy it is to solve all the questions if you have understood the passage. Yeah, every now and then you'll be getting a question or two in which you might get confused, but that is all right. The more you practice, the more better and more efficient you become. So on this note, I'll conclude for this passage and I'll conclude for today. Thank you so much for watching. Keep on watching all the videos that we upload regularly on our channel, on our official channel of CLAT Gurukul. I'll see you next time. Till then, thank you so much and take very good care of yourself.